Allowing Alan Lintner access with his service animal does nothing to modify the nature or recreation that takes place in the pool area at Parkview Terrace, and as such, the service animal should be allowed access. Allowing disabled individuals like Mr. Lintner full use of their service animals is a reasonable accommodation. Statute tells us that if an individual is disabled, that a modification should be made. Not can be made, but should be made to allow service animal access. In a public accommodation, if you're allowing the public to go there, a service animal should be allowed to go there as well.
Well, I'm going to ask you, Counsel, about the fundamental alteration of the service provided to the swimming pool. I understand maybe there's some disputed fact here, but I'm going to assume that at some point, whether it's happened now or in the future, this dog's going to jump in the pool. So isn't that a health and safety risk for the other people who are trying to use the pool?
No, sir. Your Honor, the Congress has already decided in cases like the Johnson Brewery case, where if we're allowing a person to go into an area, in this case it was a place where they were actually making foodstuffs, that if there is a person being allowed access, they pose the same exact risk as a service animal. So inherently a service animal is not to be considered a public health risk.
So you don't think that the dog swimming around in the pool isn't going to create any more hazard, like hair in the filtration system, or urinating in the pool, or pooping in the pool, than a human would do?
The dog is very well trained. The dog is not going to be swimming around in the pool. The dog is only going to enter to assist its owner from getting in and out of the pool. If the dog did have a problem with urination or fecal matter, then there's an enumeration within the statute that grants the Parkview Terrace the privilege of asking them to leave. But this is not the case. The dog has not gone to the bathroom in the area. The dog has never been out of control. The dog has not been swimming around at its leisure in the pool. All we're asking for is service access for the dog to assist its owner in the way that it is designed to assist him with his disabilities.
So your client's going to guarantee this dog never jumps in the pool and starts swimming around, or go after some other resident who the dog may perceive as a threat to his master?
As I said before, the dog is well trained. He has no aggressive tendencies. He has no violent background. If this were to become the case, Parkview Terrace has every right to exclude the animal, but until that time, the service animal should be granted access to assist its owner.
So we just wait for the bad thing to happen before we deal with it?
No, sir. If there was an indication that this animal had an aggressive background, by all means, but at this point it would just be strictly speculation, and an irrational fear can't really be the justification for denying a service animal. There are always going to be people who are afraid of dogs, but that doesn't mean that we deny a disabled individual access to any public accommodation anywhere because there might be someone who's afraid of the dog.
So it doesn't matter that the vast majority of the tenants are uncomfortable and dislike having the dog present at the pool?
The tenants have not had it fully explained to them the purpose of the service animal. To them, all they know is that it's a pet sitting there. And it's our belief that if the information was shared with them, the purpose of the dog, that the dog was well trained, that the dog has no aggressive background, and that it's the right of the owner as a disabled individual to have that dog there with him in the public accommodation, that would allay a large majority of the fears.
Okay, Counsel, so let's assume all that's true. What's your modification?
To allow access for the service animal. That's all we're asking.
Well, that's not a modification, that's on a middle ground. They have a policy that says no dogs, and you want to have a dog allowed. I mean, you want the policy modified 180 degrees. So that's really a complete change in the policy. It's not modifying their existing policy to provide for your clients access with their dog. I mean, is there a middle ground?
Your Honor, we're not asking for a complete modification that allows access for all animals. We're asking for a modification that allows access for service animals who are specifically trained to assist their disabled owners. And there is a distinction between your everyday family pet dog who has not received the same type of training as this animal and a service animal that provides assistance to a disabled individual. Opposing counsel may try to argue that Mr. Lintner's service animal is not a necessary assistance. The pool has railings. He has his friend who's a guest. However, Congress has made it clear that a service animal and their owner function as a unit and should never be involuntarily separated. We have case precedents that demonstrates this. And there was a concert hall in Lentini where the concert hall provided trained ushers to assist disabled individuals. And even in this case, where there was specially trained individuals to assist, the court ruled that this was not sufficient and this was not an adequate substitute for a service animal. Providing access to privileges given to the able-bodied public is reasonable. Denying full access, any access to a service animal that goes with a disabled individual is not reasonable and is not in keeping with the congressional intent to provide the broadest feasible access.
Well, did I understand from the facts that, in fact, your client's friend, the resident there, was helping him get in and out of the pool and the dog wasn't really actively involved?
There were occasions, sir, where the friend was assisting. However, there were other occasions where the dog provided assistance. There may be days where Alan Lintner feels comfortable getting assistance from a friend, but muscular dystrophy is a degenerative disorder. There are going to be days where he feels stronger than others, and on the days that he feels he needs his service animal by his side to provide the trained assistance that it can, then he needs to have that right, and he needs to have that dog present.
Thank you.
In conclusion,
No, thank you.
That's done. Right, thank you, Your Honor.
May it please the court. I am Gus Skank, appearing on behalf of the appellee, the Parkview Terrace Apartments. My co-counsel today is Matthew Thornton, and we respectfully request that you uphold the lower court's finding that the pool at the apartment complex is not a public accommodation. The pool is not a public accommodation. It is an amenity provided by an apartment complex to its residents. The residents pay for the operation of the pool through their monthly rent. And even though we will see that it is a place of exercise or recreation, the swimming pool, it is not one as is envisioned by the ADA because it is not held open to the general public. We'll start off by the general law that apartment complexes
Well, it is held up to the general public because, are you disputing appellant's statements that anybody can walk in off the street and go into the pool and there's nobody going to stop them?
I'm not disputing that at all. Anyone could do that, but that is against the rule. There is a policy in place. And as was discussed in Carolyn v. Orange Park, it is the intent of the apartment complex that matters. It is not, though someone else could walk in, it would be trespassing and it would be against the law. The intent is for residents and their guests, and that is a special relationship that precludes the general public.
But aren't guests members of the public, don't they?
Yes, a guest is a member of the general public, but that would be similar to saying that if I invite someone into my home that isn't an apartment complex, that I would be inviting in the general public, which isn't true. I'd be inviting in perhaps a close friend or a family member, but not the general public.
But a person who is a resident at the pool, if they wanted to, could essentially see someone, standing outside of the pool, invite them in as a guest, but not even necessarily know them. They could still, be inviting in anyone from the
Yes, they
public.
could do that. It's unlikely, but it could happen. And in that case, it would be their guest, and that would be that tenant's responsibility while that person was in the pool. It still would not be the general public. Someone is still in charge of the person that was invited in, the tenant that invited them. Apartments are not covered by the ADA. Both Independent Housing Services of San Francisco and Lancaster v. Phillips dismissed claims by plaintiffs alleging ADA violations in apartment complexes. The courts in both cases held that it's simply irrelevant. The ADA is not applicable to apartment complexes. However, that doesn't settle the issue for us because what happened took place in a common area of an apartment complex. However, there's no case law saying that the common area is instantly part of the ADA, covered by the ADA. Carolyn v. Orange Park, the court in there, cited a letter written to the Department of Justice that reads in pertinent part, if activities in a clubhouse within a residential complex are intended for the exclusive use of residents and their guests, the facility is considered an amenity of the housing development. It would not be considered a public accommodation subject to the accessibility requirements of the ADA. Our swimming pool can be seen just like this clubhouse. It was the intent of the apartment complex to have residents and their guests use it, demonstrates not a public accommodation. It is simply an amenity. Even more persuasive in this very same Carolyn case, what was at issue was a series of recreational trails that anybody in the public could access. So as you posed a question earlier, what if someone walked in? Someone could walk in and use the pool. Someone could have walked in and used these trails. However, the court specified that it was the intent of, in this case, it was a housing development where people paid dues. And it was their intent to use it and upkeep it for their residents. Just as it is the intent of the Parkview Terrace Apartments to limit access to residents and their guests. As cited earlier, Burke v. Oakwood, the court in that case held that even though there was harm that occurred in a common area, it didn't matter because the common area was not covered by the ADA. It was simply part of a residential apartment complex that is exempted from having to meet those specifications.
How do you respond then to counsel's distinction that the Burke is inapplicable here because it dealt with smoking and not dogs?
I would say that it is a different harm, but they're both harms. The dog has caused members of the apartment complex to feel discomfort, just as smoking would have caused members of the apartment complex to feel discomfort. And in both cases, it should be held that it simply is irrelevant because it is not covered by the ADA. The common area of an apartment complex isn't covered. So whether it's smoking, dogs, any other annoyance that happens in there, it doesn't have to meet the specifications of the ADA because it is a completely separate issue. It is a private residence.
But why isn't the swimming pool part of the common area? I mean, are you saying,
No.
are you saying, just excuse me, are you saying that this dog and Mr. Littner cannot walk around in the other areas of the apartment complex that are common to everybody else?
The apartment complex has the ability to disallow anyone they wish. It is their policy to allow guests, and as such, they can take that policy away. Mr. Littner has unfortunately abused that policy. He has brought his dog into the pool every day with him when it's not necessary, and it is within the power of the apartment complex.
So you're banning the dog. I understand your point, but why are you banning Mr. Littner?
We're not necessarily banning him. If he does not start behaving as we would like him to behave or following the policy of not bringing the dog in, because
actually, as I read the letter that your client sent out, it says that Littner is not welcome.
Mr. Littner is not welcome to the pool, and that is okay. You do not have to let anyone you want into your private home.
Okay, and I misstated this. It says Littner was not welcome to bring his dog onto the apartment complex, not Littner himself. So you're allowing him on there, right?
Yes and no. It doesn't matter whether or not we allow him on there because we have the ability to not allow him. We do not need to allow the dogs. We don't need to allow him because this pool is not a public accommodation. A public accommodation has to be held open to the public, and the swimming pool has not been held open to the public at all. It's been held open to a very exclusive amount of the public, guests of residents. And that's not the same as saying we've opened it to the entire public.
So you found a loophole in the law that allows you to discriminate against this fellow?
I wouldn't call it a loophole, I would call it the law. What if someone came into a person's home, like your private home, you could consider having a pool in your backyard, and just because someone comes that, say they have muscular dystrophy and they have a service dog, you don't have to let them into your private pool if you don't want them to. That's not a loophole, that's simply the law. This swimming pool is at a private residence. It's an apartment complex, which is viewed a little bit differently, but it's still a private resident. Every resident in that complex deserves their privacy and deserves to enjoy their pool free from fear of a large dog, just as anybody at home deserves to use their pool free from fear of a large dog.
Thank you.
Your Honors, and may it please the Court. My co-counsel came up here and told you that we are requesting that this Court affirm the lower court's decision and find that Mr. Littner has not been discriminated against under the ADA. Two further reasons that we ask the Court rule this way. The policy modification being requested is not necessary for Mr. Littner to access the pool area. Secondly, A policy modification in these circumstances would fundamentally alter the nature of the pool. Now, Your Honors, if I may respond quickly to the points of opposing counsel Ms. Carty, she talked about the Congress's intent, and that Congress's intent was to provide broad access to disabled individuals, and this is true. But Congress' intent was not to provide blanket access to service animals as said in Poole v. Riverside. Additionally, it has been stated that the dog is highly trained. Nowhere in the record is it stated that the dog is highly trained. All that we know for sure is that the dog has general obedience training.
Well, I think we can assume that he's highly trained because he's been designated a service dog for this particular fellow who has a specific kind of illness and needs a very specific kind of help. So I'm just going to tell you that I'm going to assume that he's well trained and that he'll do what he's told. And so I'm questioning why you can't allow it. Well, am I not correct that the dog really hasn't been the major source of assistance to Mr. Littner while he's in the pool, that it's been his friend? And so how's the dog bothering anybody?
Your Honor, you're correct. The dog has not been of assistance. The friend has helped Mr. Littner get in, out, and around the pool. The dog, at this point, has not attacked anybody. The dog has sat quietly beside the door, and really the only threat to the other 37 individuals at the pool is his appearance. The fact that he wears a spiked collar, is a large German Shepherd, and is sitting unrestrained on the pool deck.
Well, that's kind of an irrational fear, isn't it?
Well, I don't know if you could call it irrational, being that 37 out of the 53 pool members all feel the same way. Even if it is an irrational fear, it's still a fundamental alteration because it changes an essential aspect of the pool provided at a cost to the residents.
Well, I hate to see the mob overrule the little guy here. And isn't that what you're allowing here? Because aren't I also correct that your client never made any effort whatsoever to figure out what was actually going on, never met with Mr. Littner, never met with the dog, never watched the dog interact with anybody else, just took these letters, this petition from other people and decided to make an arbitrary decision without really investigating it or determining for themselves that there's a problem, and if they determine that there wasn't a problem, go and making some effort to get the rest of the residents to understand what's really going on here, and then everybody can live, let's all get along. How about that?
Your Honor, you're right. The apartment complex did not reach out, but I will emphasize the fact that in Johnson v. Gambrinus, the RILE framework was set out. And this is the pleading standard for Title III cases. And that requires that the plaintiff, the disabled individual, makes a request. Now, that's not disputed in today's trial, but that's important to talk about given your point. If the apartment complex would have had notice that this man was disabled in the circumstances and that the dog was a service animal, which the letter sent to the disabled individual does not indicate that she knew that. She calls it a pet, I believe, in the letter. Then
why didn't she know that?
I'm sorry?
Then why didn't she know that? I mean, that's a pretty basic thing that she should have figured out before just arbitrarily sending somebody on their way.
Your Honor, I'm not sure that there's a burden that's placed on an individual, given the circumstances, to determine her knowledge of service animals. While I understand the point being made, is not necessarily relevant to the response of the apartment complex given the circumstances. Again, the circumstances are extreme, and I don't think in the future this would bar other individuals necessarily. A fundamental alteration has occurred, and not just for safety considerations, as Your Honor brought up earlier, but because the core business of the apartment complex could be affected by a policy modification. And that is evidenced by the fact that 37 residents signed a complaint and they paid for the pool.
And the core business of the apartment complex is to make money, isn't it?
Yes, sir.
That puts it under the commerce clause thing, and doesn't that then relate back to the requirement of the ADA?
No, Your Honor, because that would be saying that any place that makes money is then a public accommodation. And I'm not sure that Congress intended for that result. To go back and talk about the fundamental alteration, it's not just the core business that we can talk about. It's also the essential aspect of the pool that's being denied to the residents. Now, the apartment complex policy is to provide an environment that is very much similar to owning their own pool. And again, it's the intent of the apartment complex that matters. And the fact that the dog's sitting in there and scaring off residents is really, it's changing the entire reason that the apartment complex has the pool in the first place. If people can't use it, then what good is the pool to them? Something we haven't talked much about is the necessity of the service animal. Now, again, this is a special circumstance because there is somebody that is there, able to provide mobility assistance, and is not only just there, but is there and has to be there.
You really want to argue whether this dog is necessary for this particular disabled person?
Your Honor, I think it is. It's not the strongest argument. I will concede to that point. But the evidence shows that the disabled individual in this case has not relied on the dog. And in fact, I think it's important to ask how a dog could be of assistance to a disabled person that's swimming in the pool anyway, for mobility reasons. So, no, I don't think that the dog is necessary in this situation.
Well, it might be necessary to take the man to the bathroom. Is Miss Henning supposed to take him to the bathroom?
Your Honor, being around pools a long time, I could say that pool might be the best option for that situation. In all honesty, that is a great point. But
okay,
again,
we're done. Thanks. Got to quit on a high note.
We're moving to the feedback phase of this event.
You'll go last or first.
I'll go first.
Okay.
Overall, I thought all of you did very well in that you had a good understanding of and knowledge of the facts and the case law. I thought most of you did a good job, being able to take the question and respond well to it. Sarah, watch your feet when you're talking. You're kind of like moving around a little bit when you're talking, but I felt like you gave really good, confident answers when the judges were asking you questions. Jen, I thought you had a really nice pace. At the start, I really liked the pace that you were going at. Again, I thought you gave good responses. I thought both of you probably could have, analogized to case law a little more than you did, but I thought that your arguments that you gave were still strong. Gus, I thought out of the group you probably came across as probably the best advocate. You were very, very strong and confident in your speaking. And I thought you referenced the case law really well as you were going through your argument. Matt, I liked that you gave kind of a roadmap at the start of yours. I know you were second, but I liked that you kind of referenced where we had come from and where you were going. I thought that was good. And I also like that you responded to your opposing counsel's argument.
You can have the wrap up. I'm sorry. That's the best answer yet. Pee in the pool. I like that one. There's a lot of other people. They hear it for the first time. They're thinking, "Oh God, she's not going to take this guy to the bathroom." And you're the first one to say, "Just take a piss in the pool." Let's see. Overall, I do think he did well as well, and obviously. As we've stated to other folks that have been in here, part of this is to get an idea of kind of what it's like. You will very rarely ever get through what you think you're going to get through in an oral argument or an motion hearing or something like that. Particularly with appellate stuff, a lot of times the judges kind of are leaning, if not outright, knowing which way they're going to go, and they're looking for either tidbits, oral arguments, things like that, so that they can write it up and make their decision supportable, or some smoking gun that means that they've got to change that vote. And so the big part of the getting interrupted and things like that. Coming prepared is paramount, and knowing not only your piece, but pieces that your partner is supposed to be arguing, knowing your facts, knowing your law, and I think most of you did a pretty good job of citing law. Speaking individually, I definitely think that Jen did a good job with some of your points. Something nobody's really highlighted yet that she did was the case law that says there's no difference between a man and a dog. And I thought that was something that was really hard that not a lot of other people have brought out. And there's all these distinctions made about it. Here's a case that says, a person can be standing there, a dog can be standing there. So basically, you're upset that this dog is sitting near the door. Well, so you're upset that there's a guy near the door with like biker leather and tattoos, and you're afraid he's going to get up and beat you down before you get to, I thought that made pretty good sense. Some of the other points that I think Sarah hit on as well were good. But particularly the fact that we didn't really let you get going. And I think you handled that really well. Gus, your legal arguments, your citation, I thought, to case law was probably the most effective in the sense that you did a really good job, I thought, of wrapping them into the sentence that you were talking about so that I get the case citation, but I also get its application to the facts of this case at the same time in the same sentence, rather than just the standing up there and kind of saying, well, there's a case that says this and a case that says that. You were very kind of quick with your responses in terms of, yeah, well, there's this Burke case and it says this, and that you were using the case law to respond directly to the questions, which I thought was really effective. And I liked, Matt, I liked your response on the notice. But one of the things I've told every group so far is that you always have to hone in on your key problem. Your key problem is that it's a hell of a tough road to hoe to make this a public accommodation. Your key problem is that your client really just comes off as, I don't want dogs at my pool. And you've got to do what you can do to wrap that concept in and battle it back. And so that notice argument is a key area where you want to make a decision how to use that, because it's great as a way of saying, well, look, it's not like we didn't do anything. The statute requires this guy to start the process. And so I understand that kind of ameliorates a little bit this kind of hard line that he's taken, but you got to be careful that doesn't come off as, one of the worst things I think you can do is you can say, instead of explaining why you did what you did or why the situation is like it is, you say, well, he's doing it too. So that's the piece of it that you want to stay away from. And so that's why you can temper that notice. I think you've got to get it out, but it's got to come out in the right way and on your terms. Otherwise, that's what the opposing counsel is going to just jump on. They're just going to say, so you're not explaining to me why you didn't look into all of this stuff. You're just basically telling me that it's his fault I didn't look into it. So yet again, there's that piece of it where it can kind of come off as smacking of, you've got to do everything, every chance you can, every sentence, every comment, every piece of information that you talk about, you've got to be combating that overall kind of thing, which is the person that runs this apartment complex doesn't want to do anything to help out this disabled guy. And that's one of the reasons why I thought we were trying to open the door a little bit, and nobody stepped through it, which was one of the best things you can do here, particularly for your case, but specifically for yours, is what did you offer in between? What type of modification would you suggest? And that's why I was trying to get to, again, a modification. I don't necessarily think that always means you're going to completely throw out the old and come in with something new. And that's really what you were arguing for. The policy as it exists right now is no dogs. And so, we had another group come in here, and the guy for the dog owner side got up and he said, well, what about a $5 hook on the wall? that we can tether the dog as well, so that not only will the dog not move because it's super obedient, but it also won't move because it will be physically restrained from moving somewhere. And now, that's a modification, maybe not to that specific, that one policy, the no dog policy, but it is a modification that bridges the gap between the two pieces. And a lot of times you'll get jurists that are looking for that kind of, can't we all be happy kind of type situation. You should come prepared for that. You guys as well, you look eminently more reasonable if, you say, well, look, we offered to do this. We offered to, put a little crate area in there to put the dog in, or we offer a little kennel or something like that, some type of thing that meets halfway. Instead, what it looks like is it comes out as when nobody offers that, neither one of you gets the benefit of that for what your argument looks like. You guys don't look like you've been trying to work with them. You look like you're saying he's disabled and he wins. And you guys don't look like you've been trying to do anything either. You look like he's disabled and I don't give a shit.
So the facts here may constrain you, though. I mean,
they do. They do.
Given that opportunity.
Yeah, and that may be the case. So, but otherwise, I think, good job.
Okay, so Ms. Malarchek, say it again.
Molnarchuk.
Okay, you say so. Well, here's the deal. If we go strictly by the law, you guys win. If we try to be a good guy and try to be fair and righteous, then you guys win. But as he said, that public, whether it's a public accommodation thing, it is a hard argument to make. And I thought you did as good a job as you could, even though I don't think you win on that argument, you still did a good job trying to do it. So that's really to your credit there. Ms. Carty, you had, I wrote down you had very good responses to the questions. You came across as knowledgeable and understanding what the issues were, and you answered our questions. To reiterate what Brent said here, he wanted you to bite on coming up with some sort of compromise, and you just didn't want to do it. It's an all or nothing proposition. And even if it wasn't in the system, in the problem, maybe you got to. This is a case where you listen to what the judges are going, and if you can see some way that you can still win, maybe you got to go with the way what sounds like the judges are headed. So that would be my only criticism there. But the facts weren't presented that way, so I appreciate that. But here's an opportunity to think on your feet and see what you can do. Mr. Schenk, amenity provided. The first thing you said, that was exactly right. I'm glad you did that right. The Caroline case, that's exactly right. That's the one you want to go for. I thought you had a very good use of your other cases. Now I'm gonna bring in my colleagues here because I don't know. I got 2 points I don't know the answer to. The first one is you have a big voice, and a big voice is good, but especially when you were talking to Rachel here, you didn't sound conversational. You did. And I was going to say, if you're making your argument, use your big voice, but then when you're answering questions, tone it back a little bit. Would you agree with that or not?
I think so. I mean, certainly not as pronounced as some other groups we've seen today. But
we just commented. We just had two prior females who had the big voice, and we complimented them on it. But I cautioned them to suggest that a male might be able to get away with that, where a female wouldn't. But now I'm thinking a male shouldn't get away with that either, if it sounds sort of like your tone of voice is more pushing at me rather than.
And I did get that a little bit. I mean, just a little bit. But again, it was not as.
Yeah, I don't know where the line. That's why I'm asking them. I don't know whether that was good or bad, but I thought I'd bring it.
I think I liked it at first, like when you're starting to, present your argument. But I think I agree that, in terms of the questioning, I feel like it's almost just continuing to force the argument rather than continuing to have a conversation.
Was I coming off aggressive? That's fine if I was, please be honest.
I think to a slight extent.
Okay.
It's just the tone. What you said was really good. I didn't have any problem with anything you were saying, and I didn't have any problem with the fact that you took command of the podium and the room. But then when you get talking to a judge, it's better to be a little more conversational. Now, women are more naturally good at that because they don't tend to project their voice quite as much, but you do need to speak up, and you didn't have a problem with that either. You guys were just fine. And I thought, and I thought you were very conversational. So I thought you did it perfectly. I didn't know, and I was just asking them whether they thought that was too much or not, and I still don't know. The other question I had about something you did was, you brought up the issue about common area, which is a point for them, but they didn't bring it up, and we didn't bring it up. So should he have brought it up?
No, this was another one of like the box. We were talking about how knowing you're ahead. If a judge has looked at something in a box and did whatever with it, put the top on it and slide it aside, don't pull the box back in front of him or her again. Like, you got out of it because, I mean, obviously, like, you know, the common area part of it is detrimental to your case. I mean, what I think your better argument is what you guys both hammered on, which was, look, this is not different than somebody's house. This is not different than a pool in your backyard. And if you don't want to let a guy with a dog in there, you don't have to. And that's what we've got going on. It's not public. And so, yeah, don't.
Okay, in front of a jury, if this is a jury trial, you have to do those things because you have to assume that they're going to be thinking that because they don't have to talk to you. But in this environment, they didn't bring it up, we didn't bring it up. Don't say something that doesn't help you because then you sound offensive. So that was my point there. Okay. Is that a real bow tie? Did you tie that tie?
Yes.
Okay. Under that circumstance, it's okay.
So
I don't know why I don't think a bow tie ever looks good, but if you tied it yourself, knock yourself out.
That's Southern charm.
Again, I've already, my other two comments were, again, you had a very good conversation voice, and I thought your responses to our questions were very good. So all of you did an excellent job with what you had to work with, and keep at it.
Thank you for your time.
Do you guys have any questions for the judges?
I had a question, now I forget it.
That bow tie comment just threw
Yeah.
it right
I
out.
did, it totally.
bow ties and peeing in the pool. We're outside the box.
Actually, I did have a question. I know you probably shouldn't use very much humor, but anyone like that knows me knows that that's sort of my MO. And I didn't, and that's why I maybe was a little aggressive. I was focusing so hard on it. Can you ever infuse humor into it?
Yeah, as long as you're not sarcastic. And that is my biggest problem. I'm Mr. Sarcasm, and I showed disdain for my opponent through sarcasm, and every time I do that, I say, why do I keep doing that? Because it doesn't come across. But when I do voir dire of a jury, man, I'm making jokes left and right. I want them to like me. I want them to relate to me. So I use jokes all the time. So yes, it's okay. I'm not sure how effective it is in an appellate argument standpoint, but in a trial where you have a jury, it's certainly, absolutely.
And depending on subject matter, obviously.
Yeah, don't make it
Yeah.
ill-advised joke.
Well, no, I mean the subject matter of the case too. It's a very, somber type case and something like
Well,
that.
I do personal injury, and I go in and I say, this is a serious case. It's serious for the plaintiff and it's serious for the defendant, but the world's going to still revolve tomorrow. The sun's still going to come up. This isn't life and death. Nobody died here. Nobody's going to go to jail, So in that way, I'm trying to lighten it a little bit so they can do it. If they are going to go to jail, well, then don't do that. But you figured out.
I did remember what it was,
Okay.
yeah. So you mentioned coming up with some sort of middle ground. So in this case, would you do that? Like, let's say, for instance, that I believed, as I do, that I don't want to make an agreement. I think he should have access with the service animal. Let's say that's my hardline stance. If I know that my argument is weak in another area, like, for example, we know that public accommodation is going to be hard to sell,
is it a good strategy to go with a compromise because of that? Or would you still, if you really just like adamantly felt like this was a hard line that should be accepted, continue to go with it?
Okay, well, if we're talking about slavery or segregation in school, then you gotta be hard line. But these other things, the world works through compromise. That's why nothing's happening in Washington, because nobody wants to compromise. It's idiotic. It's just a fact of life that you gotta do it. And so take a hard line when it's really an earth-shattering issue, but if it's not, and this borders on it because the guy's disabled, but now I think, from our standpoint, we're looking at this and going, why are you people here? Why
Right.
couldn't you figure this out? Okay, well, you're here because that's the problem, and that's what you're doing here. So we greatly appreciate the fact that you're constrained by the information you've been given and the fact that you got to use this as a problem. And we're impressed by those people who kind of go a little bit outside that and come up with something. It sounds cool. Pissing in the pool. Okay, there's a movie.
And you have to, because, judges and juries, they're looking for that. They want to, because, really, at the end of the day, there's the law and there's what the statutes and the case law and all that say, but again, there's that piece of, just real world, is this right or wrong? It's like the Supreme Court said, well, I don't need a definition of pornography. I know it when I see it. And it's that same kind of concept of, you can know that,
Although I need to further review the evidence.
Yeah.
But all this talk is making me go to the bathroom, so I'm going to go.
But yeah, so anyway, the bottom line is, I think with that whole, with the compromise piece of it, is there, in the real world, you would have had an opportunity to do those kind of things, but long before you went to trial, long before you got to an appellate court or anything like that. But even just to throw that out at an appellate level, because again, that you can skew how people view you. And if they know right and wrong, then they generally know. The bottom line is, most people probably are going to say, well, look, whether you're scared of a dog or not, they're probably going to say, well, there's got to be some way, some middle ground where this guy can have his dog reasonably close to him, and the other people can be, a lot less scared. And so something like that, well, we've offered to, or we want to see if we could have a tether, or because some of the comments we discussed was well, so what if the dog sits outside instead of inside? Because that's one of the things, some of the arguments here are almost really red herrings, is a pool or recreational? Come on. Yeah, good luck arguing the converse of that, but those type of things, because, and I always say that, and you'd be surprised how many lawyers I just really think don't understand what the word compromise means. That means we all go into one room and we all come out rubbing our asses. And instead of one person doing the Rocky dance and the other guy's crying. That wasn't a compromise, it wasn't a good settlement. That, somebody, basically you all come out of it giving up something. That's what compromise is. Everybody has to sacrifice. And it never ceases to amaze me how many lawyers and clients don't understand that. And, and I try and tell them, you're never going to get anywhere like that. I've told them before, sure, you could compromise. I know you don't want to pay this guy anything, but he wants $500,000, and he just said he'll take 20 grand to leave you alone. Well, I don't want to pay him a nickel. Well, okay, fine. Then we'll go to trial, and you'll pay me 6 figures for a shot at being able to tell him I told you so. So if that's a $120,000 I told you so that you gotta have, go for it.
Is this another word?
No.
It's about compromise more.
It's just compromising. Yeah.
Okay.
Well, thank you.
Thank you.
Thanks, everybody. Good job.
somewhere before, and then put it in there or something.
I'm with Burleson, but I've been a mentor and doing this for Deb and other people and talking against.
Yeah, he spoke earlier at
7 years, 9 years,
If you
something.
spoke earlier, that would be why your face is
I was on
My memory
a
was so good
panel
that I
for,
didn't
I was on a
That's what it
panel
was.
for Deb.
Oh, that's
Oh, yeah. I was
familiar.
Yeah, I generally just always say yes to her, so.
Thank you.
Thank you.
You get out this way?
For your benefit, I knew everybody's name before, so
Yes, you
I
did.
got it right.
We're just waiting, sorry.
Are you?
I didn't want to rush Matt.
No, you're fine.
I didn't need your coat out there today.
Yeah.
Oh, the flakes got smaller.
Yeah, they just got more frequent.
It's quite the blizzard.
Don't say the SD word, because then if you'll jinx it, there won't be one.
The SD.
Yeah. The thing that everyone is thinking when they say it, please don't say that, because it jinxes it, and then we won't have to.
I'm amazed that those even happen in Colorado.
Gentlemen, did you guys get your brief back for citation? Did you like it back?
Yeah.
Pretty good. In Colgate School. And we were put snowboards. I rode a horse to school.
Shut up.
That's probably the most effective way to get there.
I feel like getting big
I
snow
don't
is.
I think I actually might have
never
your
closed school.
citation
That's
That's
website.
the coolest thing I've ever heard in my life. I don't think anybody would be allowed to even do that anymore.
Where did you
Yeah,
go to
Well, we
school?
had for crap.
You were correct.
You went to school.
Well, that's what I mean. Is it still like that?
No.
I was gonna say, like, that's what I'm saying.
I said only till 14.
Yeah, it would be cool.
Then school.
Like, when I lived in Florida, a buddy of mine, his dad used to tell us stories about how when they were, when they were younger, they'd go up to the bar to drink. They didn't want to drive home, they just climb up on the horse and
It's
walk.
still like that in Texas.
I got it. I got it.
There's a backstory.
Okay.
I just appreciate that suggestion. I think that
I didn't see she was at Huh? Well, I'm married, so it's not a problem.
I didn't know what you said.
So she's taller.
Oh, yeah. Right.
But just so you know, even if I wasn't married, I wouldn't be a problem either.
So just you, right?
Oh, no.
What?
I said, some of us have been in this room since 8 o'clock this morning.
I have.
We might be starting to lose it a little bit.
Just don't take it out on us, that's all we ask.
No, not gonna happen. So here's the way this is gonna work. Carrie's keeping time for everybody in the room. She'll hold up for each student 2 fingers for 2 minutes, 1 finger for 1 minute. This is your out of minutes. However, the minutes are controlled by our panel of judges. So you guys don't stop yourselves, you don't dismiss yourselves. You'll perhaps be engaged in answering a question or listening to a question. So the judges will be the ones that determine when you're done with your argument, so follow their lead. Carrie's just keeping time for the benefit of everyone.
So do they do the countdown for each 7.5 minutes? or
Yep,
of the
every
total?
single student will
Okay.
get that countdown and that signal, so you know about where you stand. So any other questions? Okay. So counsel for the dog owner can get started.
May it please the court. My name is Jeff Lee, counsel for appellant Alan Littner, and this is my co-counsel, Sammy Robb. We request that any remaining time be used for above. Mr. Littner suffers from muscular dystrophy, which is a qualified disability under the Americans with Disabilities Act. Because of his disability, Mr. Littner requires the use of a service dog to complete even the most basic tasks, such as standing from a seated position. As a guest lieutenant, Claire Hennings, Mr. Littner used the pool twice weekly for a period of 6 weeks to help lessen the symptoms of his muscular dystrophy. After 6 weeks of using the pool, Mr. Littner was barred from using the pool because there were complaints about the service dog that his disability requires he have. The pool area at Parkview Terrace is a public accommodation subject to the ADA because it is a place of exercise or recreation. The ADA has 12 enumerated categories that make up what it constitutes to be a public accommodation. A place of exercise is found under category L of these enumerated categories.
I'll tell you what, counsel, I'll tell you and opposing counsel that we're going to call a swimming pool a place of exercise and recreation.
Okay.
And so that's going to be a given.
Okay. Historically, it is true that residential apartment complexes have not been subject to the ADA. And there's a good reason for this. It would be economically unreasonable to force every single dwelling to be constructed through ADA specifications, because it's unlikely you're ever going to have an apartment complex that has nothing but disabled tenants. However, most recent courts have started to differentiate between the dwellings that tenants reside in and the locations around the apartment complex that no tenant personally resides. Courts have found that sales centers, leasing offices, and others locations that would be enumerated under the ADA would be considered public accommodations. And furthermore, they have stating that a place that is enumerated under one of the categories of the ADA, it is stated as a public accommodation, would be a claim for which relief could be granted. And this is very important in Mr. Littner's case because the district court ruled that he did not have a claim for which relief could be granted. Opposing counsel may point to multi-family homes and duplexes as reasons for why a pool area would not be a public accommodation, and this is because we would not consider a pool area at a duplex or a multi-family home to be a public accommodation. However, there are stark differences between a multi-family home or duplex and an apartment complex.
Counsel, I think we need to define the word public, and it's my understanding that this apartment complex restricts use of its pool to its residents and their guests who are accompanied by their residents. Isn't that correct?
Yes.
Well, then how? There's no public. It's the residents and their guests.
The guest, it's not just limited to a few people. It can comprise thousands of individuals. It's virtually limitless because you could be a friend of a friend and still be considered a guest. I mean, so there's really no limitation to what that means.
Well, I don't think that's right. It says the resident and his guests. If the resident doesn't invite you, then you can't come in. Isn't that correct?
Yes.
So the friend of the friend isn't going to come in unless he's been invited by the resident.
You can say, well, I'm going over to my friend's pool. You want to come? And then, oh, okay, yeah, come. Something like that. So I'm sure it's a frequent situation that comes up.
But not just anyone can.
Furthermore, anybody could be a potential, because you could meet somebody that lives there. I mean,
So I'm walking down the street and it's hot, I see a pool. I can walk in there and jump in that pool?
no.
Okay, what if I go to the manager and I say, hey, here's $10, can I go use your pool?
No.
Okay, so
But my point is,
how does that make,
it's just that the
I'm the
sheer
public,
number-
I'm the public on the
the sheer
sidewalk.
number is so much larger than like a duplex or a multi-family home of potential people that know people that could be guests.
Just because there's a large number doesn't mean that it's public, though. It's still not open to anyone and everyone. The
True.
number doesn't.
But there are other differences too. I mean, they have faculty there. They have people that work in the sales office. Somebody cleans that pool every day. I mean, that is another difference in an apartment complex, which is a place of business, and say a duplex or a multi-family home.
But we weren't the ones that brought up the duplex. You were. I don't know what that has to do with anything. As my colleague pointed out, that the number of people that could potentially utilize the facility doesn't make it open to the public. And isn't this, in fact, an amenity that's being provided to the residents and their guests? It's not something that people pay to go in and use.
Well, they pay for what they rent, so you mean...
Well, the resident may,
Yeah.
but their guest doesn't. And in this case, isn't Mr. Littner a guest?
Yes, but is being afforded, but it brings me to the privilege aspect. It's being afforded to non-disabled guests. The only specification about a guest here is that he's disabled. Nobody is being denied access to this pool under any other kind of restriction.
Well, that's a different argument, whether he's being discriminated against because he's disabled. The question here is whether it's open to the public or not.
And I'm saying that because it isn't, the courts have found that places of residential facilities, that the residential facility itself may not be may not be a public accommodation, that places inside that facility are public accommodations.
How does that contrast with, for example, the Burke case?
In what case?
The Burke case?
I'm not sure.
Well, Burke says that no part of an apartment complex is a public accommodation.
Well,
It involved smoking. We were smoking, they were trying to say it was an ADA issue, and they, you know, in all the common areas, and the court said no. The entire apartment complex is private.
well, that's one case. There are many other cases that have found that it is a public accommodation. And when it comes to the privilege aspect of it, because this privilege is being afforded to each and every guest of a tenant, and the only restriction is because of his disability, that violates the privilege aspect of the ADA.
But once again, I think we're on two separate trails here, Mr. Lee. We're not here to talk about whether he's being discriminated against because he's disabled. Your point is that this is a public accommodation, and under the ADA, if it's not a public accommodation, then they can in fact restrict anybody they want. And I still haven't heard why this is public. It's a residential community, which I believe one of the cases specifically talks about residential communities aren't liable or aren't applicable to the ADA. And beyond that, there is a restriction on who can be there. So I'm still not understanding.
Well, my point was that because courts have found that these that fall within these 12 enumerated categories are can be public accommodations, that if it is a public accommodation, this privilege would apply. Now, my argument with the public accommodation is because a place of exercise is enumerated in the ADA statute. So, and courts have found that things that are enumerated that are not dwellings are public accommodations. So because it is a public accommodation, and courts have found in very closely related cases that they are public accommodations, that the privilege would apply, and then discriminating on the basis of his disability would violate the ADA.
Okay, thank you. I think that's fine.
And now my co-counsel, Sammy Regard, will talk about the service animal modification.
May it please the court. My name is Sammy Regad, and we are representing appellant Alan Linder. This case is remarkably simple. The Americans with Disabilities Act states that a public accommodation shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to afford goods, services, facilities, privileges, advantages, or accommodations to individuals with a disability, unless the public accommodation can demonstrate that making the modifications would fundamentally alter the nature of the goods, services, facilities, privileges, advantages, or accommodations.
Oh boy, that was a long sentence to be that simple. I'm going to go to the fundamental alteration right off the bat here.
Yes, sir.
If there's a dog in the pool, wouldn't that cause a problem for other people who would be in the pool?
Yes, Your Honor, if the dog was in the pool, but in this case the dog never entered the pool.
Never ever?
Never ever entered the pool.
And you can guarantee that he never will enter the pool?
Yes.
How do you do that?
Well, sir, he's a well-trained service animal. He responds he responds to verbal commands. So to this date, he has not entered the pool, and we can pretty much guarantee that he's never going to enter the pool.
Then why did 2/3 of the other residents sign a petition saying they're scared of the dog?
Well, being scared of a dog, Your Honor, is very different than a sanitation issue. So if they're scared, it's an unreasonable fear to say that just because this is a large dog that he's aggressive and that there's reason to be scared of him. This is not just a pet. This is a service animal.
So we're supposed to just dismiss the 2/3 of the residents there and say your fears are irrational, and therefore we're not going to play this game?
Well, Your Honor, I think that there's certainly ways to mitigate that, and we can wear something that identifies him as a service animal, maybe do some educational approach so that everybody else is not that afraid of him.
Okay, that'd be a good idea, but what are you going to do, what's your client going to do to help, to come to some sort of middle ground on this case?
Well, Your Honor, in this case, ultimately it's an irrational fear. So our client does not...
Perception is reality, counsel.
Correct, I agree with you. So I guess is there another...
Do you have a modification in mind here from your side that would satisfy both parties?
Well, Your Honor, the Johnson court ruled that a blanket no pet policy does violate the Americans with Disabilities Act. So the policy currently in play is in direct violation of the ADA.
Right, but his question wasn't that. His question is, how do you change no pets to what you want in a reasonable manner?
Well, we believe that a service animal is very different than just an ordinary pet. A service animal requires specific training to the disability that the individual...
Let me sum it up. You want them to be allowed, you want an exception to the no pet policy for service animals, correct? And your opposing counsel doesn't want any changes to the policy at all. Is there a change that can be made to that policy that is something between no dogs at all and every service dog, no matter how freaking scary it is, can show up? Is there somewhere in between there? Is there any modification or any other type of things that your client might be willing to do to alleviate some of those concerns? Because really, these people aren't complaining about dogs, they're complaining about a scary dog.
So our client would be happy to approach the 2/3 group that is supposedly scared of this service animal with the education showing that he's not just an ordinary pet, that he is actually a trained service animal that shouldn't be subject to the normal okay, so let's see here. The Johnson court ruled that it is discriminatory under the ADA to involuntarily separate the disabled with their service animal. Opposing counsel may argue that the Johnson court reached this conclusion only after considering how much reliance the visually impaired have on their seeing eye dogs. However, Mr. Linder's disability requires him to rely on his service animal just as much, if not more, than the visually impaired. Opposing counsel is sure to argue that the service animal is not necessary because Ms. Hennings is able to support Mr. Linder. However, it is unrealistic to expect that Ms. Hennings will be able to fully support Mr. Linder after he has fallen down, or that she will be able to accompany him in gender-restricted areas such as the restroom. We can now discuss the fundamental alteration aspect of the ADA. The facts here are very similar to Lentini court analysis. Hercules in no way frustrates the nature or purpose of the pool by sitting quietly by the door, waiting in case Mr. Linder needs assistance. Hercules does not enter the pool, nor does he interact with other residents of the apartment complex. While opposing counsel may argue that his presence alone is enough to frustrate the nature and purpose of the pool, they are basing this argument on the incorrect stereotype that has been placed on the German Shepherd breed. Under the PGA analysis, we must follow the ADA's requirement that an individualized inquiry be conducted. This specific service animal has no history of violence. While we understand that some residents may be fearful of animals, Hercules is not just an ordinary pet. He's a trained service animal that a disabled man relies on heavily for everyday activities. We've now established that the Parkview Terrace pool area is a public accommodation because it is a place of exercise listed under the Category L of 12 enumerated categories of the ADA. The Parkview Terrace pool area is a privilege enjoyed by the public because it affords the enjoyment of the pool area to all non-disabled guests of tenants at Parkview Terrace, but not Mr. Littner because of his disability. We've also established that it is necessary, reasonable, and does not fundamentally alter the nature of the accommodation to remove the ban on Hercules from the Parkview Terrace.
Okay, let me go back to my original point here. However irrational or incorrect the other tenants may be about this dog, They're afraid of it. They signed this petition. The appellee reasonably followed the desires of the tenants of this apartment complex. To not do so would be to invite them to not use the pool at all, not renew their lease because they want to use a pool, and apartment complex goes out of business. Is the ADA prepared to have that happen?
I think we're talking a lot about, you know, the other residents' feelings and how scared they are, but it ultimately comes down to what is law. It is illegal for a blanket no pet policy. There's no doubt about that. It's a reasonable modification, and it does not fundamentally alter the nature of the accommodation. The fact that an animal is sitting there under Lentini court analysis, you have to consider it just as a human, whether a human doing the same exact thing would disturb it, the accommodation enough so that it would alter or fundamentally alter it, which is not the case.
Okay, that's great. Thank you.
Good evening, Your Honors. My name is Sarah Casinas, and my co-counsel is Maria Casala. We are representing the appellee, Ms. Sophia Dubinsky, and the Parkview Terrace apartment complexes, and we are asking you to affirm the district court's decision. I will be addressing how the apartment complex is not a public accommodation as defined by the ADA because it is part of a residential facility and is not a place of exercise that is open to the public. And Ms. Casala will be addressing the policy modification issues. The common area of an apartment complex is not a public accommodation under the ADA if the common area is part of a residential facility. A common area is part of a residential facility when it is for the personal use and enjoyment of its residents. The pool is paid for by the tenants of the apartment complex and is for their exclusive use and pleasure. Therefore, it is not a public accommodation under the ADA.
Aren't common areas public accommodations?
In this case, the pool is not a public accommodation because it is exclusively for the residents of the apartment complex.
But it's in a common area, is it not?
Yes, it is.
And common areas fall under the ADA, do they not?
In this case, no, because it does not offer its services or privileges to the outside public. So therefore, it is not a public accommodation.
But anybody can walk right in and go to the pool. There's nothing to stop them, right?
The pool is under our exclusive use, or it's under our exclusive control. We unlock the pool in the mornings, and we lock it again in the evenings.
But you don't prevent people from coming in there. You don't have a guard there. You're not having anybody check IDs. You're not having anybody ask, are you a resident or are you a guest? You're not doing any of those things, right?
That is correct. However, in Carolyn, nature trails owned by members of a development association were not actively monitored to exclude the public. However, in the case of the trails, they were not a public accommodation because they were an amenity provided to the association members in exchange for their dues, and they paid for privileges to use the trail.
Okay, but you would agree that the case law allows for public accommodations within a greater area that may not be a public accommodation, right?
Yes, if they provide the service to the public. However, because the pool does not offer its services, does not let the public come in and use the pool, it is not a public accommodation.
You said they don't let the public come in, but at the same time you say you're not stopping somebody from coming in and you don't even know who's there.
That is true. We don't actively monitor the pool during the day, but again, we maintain control over the pool, and we don't ask the public to pay a fee. We only ask our residents to pay a fee to use the pool, so therefore it's for residential uses only.
Okay.
Several other cases have held that residential facilities are not subject to the ADA, and because this pool is private, for permanent residents of the apartment building, it is not a public accommodation. Residents not only pay to use the pool, but they also pay for the maintenance and upkeep of the pool, and no member of the public may pay for the privilege to use the pool. The pool at Parkview Terrace is not a place of exercise because it does not offer its services or privileges to the public. The pool is not a privilege that is offered to the general public. The only people who pay for the privilege to use the pool, again, are the residents of Parkview Terrace, and no member of the general public may pay for the privilege to use the pool. nor does the pool serve the public. It is private for residents and their guests' use only, and no member of the public may use their services. The pool at Parkview Terrace is also not open to the public. We maintain and exercise control over the pool, and we make sure that the pool, at the end of the day, there's no members of the public in there. We also do not encourage members of the public to use the pool. We monitor the pool again, and we have guidelines posted explicitly stating that the public is not allowed to use our pool. We do not advertise the pool in any way to the public or ask the public to pay a fee to come in and use our pool. Only the residents must pay a fee. Therefore, the pool is not a public accommodation because it is not open to the public. So again, we are asking you to affirm the district court's decision. The pool is not a public accommodation because it is part of a residential facility for the exclusive use and enjoyment of our residents. It is not a place of exercise because it is not open to the public, or that is open to the public. Thank you, Your Honors. Do you have any more questions?
No, thank you.
Thank you.
Good evening, Your Honors. My name is Maria Casala, and I am also representing Sophia Dubinsky and the Parkview Terrace apartment complex today. We ask you to affirm the lower court's ruling. Even if you find that the pool is a public accommodation, allowing the service dog access to the complex pool is an unnecessary policy modification and one that would fundamentally alter the nature of the accommodation. Mr. Littner does not use the assistance of his service dog at the pool. Instead, he is assisted by the resident, Claire Hennings. The service dog frightens several of the residents from entering the pool when he is present.
I'm sorry, Counselor, are you telling this court that this disabled fellow doesn't need his service dog?
I'm saying that this disabled fellow does not need his service dog to use the pool in the apartment complex.
How about having the dog nearby because that gives him confidence that he has a service dog there, provides him psychological and emotional uplift, and even if someone else is helping him in and out of the pool, would not the appellant here feel more comfortable having his service dog with him, who he relies on 24 hours a day?
Well, the case law has only addressed the issue of actually physically requiring the assistance of the dog, and that if the service animal's assistance can be equally replicated by a human being or another method, as in the PGA case, a golf cart, then it is not required to allow the service animal.
So to heck with his feelings, right?
Again,
don't have anything to
not
do
my
with his
decision.
physical capability?
I haven't ruled on it, but the case law does not speak on the issue.
Okay.
The service dog frightens several of the residents from entering the pool when he is present, denying them the use and enjoyment of the pool, and 2/3 of the residents have complained about his presence at the pool. A policy modification is required when a disabled person is unable to use the accommodation without the modification. At the apartment complex's pool, Hercules does not provide any assistance to Mr. Lindner. Therefore, allowing Hercules access to the pool is not a required policy modification because he does not perform any tasks.
Counsel, looking at the record, how often has the complex owner talked to Mr. Lindner or his friend that's a resident?
She has never spoken to Mr. Lindner.
Has she spoken to any of these people that wrote any of these letters?
She spoke with Pilar Campos, who was the head of the letter writing, and of course she has the letter itself.
Okay. And what I'm trying to get at here is that she's never met Mr. Lindner, she's never met the dog?
Not to our knowledge.
Have you ever observed the dog?
She has
and
not.
Mr. Lindner together in the pool?
She has not. We only have the information that Pilar Campos and the record from the court transcripts.
Okay, so it sounds like there's a bit of a mob rule idea going on here, which is the complex hasn't done anything to really look into this, find out if this guy needs it, if the dog is necessary or not. They just had a bunch of people that were scared by a dog, which we've heard may be an irrational fear, dictate that this dog isn't allowed to be at the pool anymore.
Well, the dog being there, whatever the reason that the residents are frightened of him, is a fundamental alteration of the nature of the pool for those residents who pay for the use of the pool. The issue of why it's a fundamental alteration has not been ruled on.
Right, but fundamental alteration doesn't come into it until you decide whether or not it is necessary.
Correct.
So that's what we're talking about, is necessary, and it doesn't sound to me like the apartment complex owner has lifted a single finger to figure out if this guy needs his dog or not.
Again, we only have the information that is in the record at this time, but we do have the information from the testimony of Claire Hennings and of Mr. Lindner himself that he does not require the use, he does not use the dog to assist him in the pool.
In the pool? What about him, in the area of the pool?
The record does not speak to it, so I don't know.
Counsel.
Okay. A policy modification is unreasonable if it would fundamentally alter the nature of the accommodation. The apartment complex has denied Hercules access because he frightens many of the residents away from the using and enjoying the pool. So allowing Hercules access to the pool is not a reasonable policy modification because it does fundamentally alter the nature of the accommodation.
What would you say about an individual, a large individual with lots of tattoos, piercings, who maybe is scary to other individuals? I mean, how would you compare the two of those?
Well, with all due respect, Your Honor, I'm not familiar of cases where a large individual with tattoos and piercings has bitten and maimed and perhaps killed anyone except for one time in Miami. But
isn't this a well-trained service dog? There's no evidence that this isn't, a dangerous dog.
There is no evidence in the record that he is a well-trained service dog. All we know is that he gained the training that an average dog would receive from a trainer. We don't know any of the details about the training. And additionally, he is unrestrained in the pool. He doesn't have a leash or a harness, which the ADA does require for a service animal.
So is that a reasonable modification then?
I'm sorry.
In other words, are you saying that you would allow the dog if the dog would be tethered?
We would be more likely to consider permitting the dog if we were shown that in fact he did have specific training as a service dog and that he did have a leash or harness as required by the ADA.
So why haven't you looked into that?
It's not actually our responsibility. The burden is on the plaintiff the plaintiff in this case, sorry, to make sure that the dog fits into the requirements of the ADA. We have already proved that he does not require the help of the dog in the pool area, so the burden now shifts to the plaintiff to prove that he does.
So you're just going to make an arbitrary decision and hope that the case law supports you?
I believe that the case law does support us.
In making an arbitrary decision without having checked it out or done anything whatsoever to try to accommodate Mr. Lindner here. Is that right?
A great part of the issue is that it does really affect the fundamental nature of the accommodation for the residents who pay for the use of the pool. And Mr. Lindner is not one of those individuals. And if the service dog were necessary, that would be one issue. But we feel the service dog is not actually necessary. There's no information anywhere that he helps Mr. Lindner at any time in the pool or in the pool area.
It's my understanding that you prohibited this dog coming on the property whatsoever, not just the pool.
That is correct.
Why?
I would have to speak with my client, Ms. Dubinsky.
Okay.
Therefore, Your Honors, because the pool is not held open to the public, and because the pool is exclusively for the use and enjoyment of the paying residents of the apartment complex, this court should affirm the decision of the court below. Further, because the service dog does not provide assistance at the pool, and because he interferes with the use and enjoyment of the pool by residents, this court should find that the policy modification is unnecessary and would fundamentally alter the nature of the pool for the residents. Thank you.
Thank you. There you go. Okay, so good job, good job. This is the last one, right? Because I've done all of them. And you guys are constrained by the facts that you've been given. And we completely understand that. And you're not graded down for sticking to just what you know or anything like that. I was kind of hoping by some of my questions that you would kind of go outside the box and you can make, you know, you can't make up your own facts, but you can make up stuff if it's not contrary to any fact that's in here, and answer our questions. So, and I got everybody's name right too, watch. 3 in a row, I got everybody, I knew who you were before you spoke.